Hello and welcome everyone to the Drishti IAS English YouTube channel. I'm Pragya with you today. In our today's episode of Target UPSC Prelims 2024 MCQs Practice Series, we'll be discussing the multiple choice questions from the subject of Polity, set 6. So let us begin our discussion for today. The very first question of our today's discussion is, consider the following statements. Your statement number 1 is, the Indian federal system is based on the Australian model of federalism. Your statement number 2 is, the federal system in India is a result of an agreement between British India and princely states. Which of these statements given above are correct? Your option A is 1 only. Your option B is 2 only. Your option C is both 1 and 2. And your option D is neither 1 nor 2. So the correct answer for this question is going to be option D, neither 1 nor 2. See, a federal government is one in which powers are divided between the national government and regional government. National government and regional governments by the constitution itself. By the constitution itself. And both operate in their respective jurisdictions. The Constitution of India provides for a federal system of government in the country based on the Canadian federalism. So it is not based on the Australian model of federalism, rather it is based on the Canadian model of federalism. The process of formation of federation, that is, by the way of disintegration, the preference of the term union and its centralizing tendency in case of emergency resembles the Canadian federalism, and that is why your statement number 1 is incorrect in nature. The Indian federalism is not the result of an agreement among the states like American federalism. So see, this is what distinguishes the Indian federalism from the federalism that is there in the USA. In the USA, what happens is the states have come together through an agreement, and that is why they have their separate constitution. That is why in USA you are a citizen of a particular state as well as the United States of America. It follows a dual nature of citizenship. But if you talk about Indian federalism, it is not a result of such an agreement. Dr. B.R. Ambedkar said, Indian federalism was not the result of an agreement by the states to join the federation, and that the federalism not being the result of an agreement, no state has a right to secede from the Union of India. The federalism is a union because it is indestructible in nature. See, if you read Article 1 of the Indian Constitution, you will find the words India, that is a union of states. You will not find an agreement, a resemblance of an agreement, and that is why Indian federalism is very different from the federalism practiced in the United States of America, and that is why both of these statements are incorrect in nature. Now moving forward to the next question of our today's discussion. So the question is, consider the following statements. Your statement number 1 is, Parliament alone can make extraterritorial legislation that is applicable to the Indian citizens and their property in any part of the world. Your statement number 2 is, the governor of a state is empowered to restrict an act of the Parliament to a scheduled area in the state. Which of these statements given above are correct? Your option A is 1 only. Your option B is 2 only. Your option C is both 1 and 2. And your option D is neither 1 nor 2. So the correct answer for this question is going to be both of these statements are correct in nature. So if you talk about Article 245 of our Indian Constitution, it states that the Parliament can make laws for the whole or any part of the territory of India. The territory of India includes the states the Union Territories and any other area for the time being included in the Territory of India. The Parliament alone can make extraterritorial legislation. Thus, the laws of the Parliament are also applicable to the Indian citizens and their property in any part of the world. And that is why your statement number 1 is correct in nature. If you ask me an example of such a law, talk about Hindu Marriage Act. If both the parties are Hindu, no matter wherever they are, the Hindu Marriage Act is applicable on them. So, what is this? This is an extraterritorial operation of an Indian law, and Parliament alone is empowered to make such kind of legislations. The governor is conferred with the power to restrict or modify the applicability of an act of Parliament in the scheduled area of the state. The governor of Assam may likewise direct that an act of Parliament does not apply to a tribal area, that is an autonomous district in the state, or apply with specified modification and exceptions. The president enjoys the same power with respect to tribal areas in Meghalaya, Tripura and Mizoram, and that is why your statement number 2 is also correct in nature. Now moving forward to the next question of our today's discussion. So the question is, in which of the following cases the Parliament can make laws on the state list? Option 1, if the Rajya Sabha declares that it is necessary in the national interest. Your statement number 2 is when the state government is not in session. Your statement number 3 is when national emergency is in operation. And your statement number 4 is when the governor of a state requests the President of India. How many of the statements given above are correct? Your option A is 1 only, your option B is 2 only. Your option C is all of the given statements are correct in nature, and your option D is none of the statements given above are correct in nature. See, the Parliament is empowered to make a law on the state list, but in extraordinary circumstances. So what are these extraordinary circumstances? So the first article herein is Article 249 Clause 1, which states that if the Council of States, that is Rajya Sabha, has declared by resolution supported by not less than 2/3 of the members present and voting that it is necessary or expedient in the national interest that Parliament should make laws with the respect to any matter enumerated in the state list specified in the resolution, it shall be lawful for the Parliament to make laws for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. And that is why your statement number 1 is correct in nature. I'm sorry, I forgot to tell you the answer. The answer for this question is option B, only 2. Now the next article is Article 250 Clause 1. And what does Article 250 Clause 1 talks about? It states that Parliament shall, while a proclamation of emergency is in operation, have power to make laws for the whole or any part of the territory of India with respect to any of the matters enumerated in the state list. And that is why your statement number 3 also here is correct. The next article pertaining to this is Article 252 Clause 1. The legislatures of 2 or more states pass resolutions requesting the Parliament to enact laws on a matter in the state list. Any act so passed shall apply to such states and to any other state by which it is adopted afterwards by resolution passed in that behalf by the House, or where there are 2 houses by each of the houses of the legislature of that state. So no single state or governor of a state can make a request to the president for legislation on a state list in a normal situation, and that is why your option 4 is incorrect in nature. When the state government is not in session, the governor of a state can make ordinances under Article 213 of the Indian Constitution. Let me know in the comment box below in which article of the Indian Constitution the ordinance making power of the Indian President is mentioned. And this ordinance making power of the governor is subject to the aid and advice of the Council of Minister. And that is why your statement number 2 herein is also incorrect in nature. And that is why the correct answer for this question is going to be option B. Only 2 statements are correct in nature. Moving forward to the next question of our today's discussion. So the question is, consider the following statements. Your statement number 1 is, the power to make laws with respect to residuary subjects is vested in the state legislatures. And your statement number 2 is, the executive power over the subjects enumerated in the concurrent list rests with the states. So which of these statements given above is are correct? Your option A is 1 only, your option B is 2 only, your option C is both 1 and 2, and your option D is neither 1 nor 2. So the correct answer, as you are guessing it right, is going to be option B, 2 only. So residuary subjects are those subjects which are not enumerated in any of the 3 lists mentioned in the 7th schedule of our Indian Constitution. And who has the residuary power? It is the Parliament of India. It is vested with the Parliament of India. It is not vested with the state legislatures. And which article states that? Article 248 of our Indian Constitution. It specifically states that under the Indian Constitution, the Parliament has exclusive power to make any law with respect to the residuary subjects. This includes the power to levy residuary taxes along with residuary powers of legislation, and that is why your statement number 1 herein is incorrect in nature. With regard to the matters which are in the concurrent list, where both the Parliament and state legislatures have the power of legislation, the executive power rests with the states, except when a parliamentary law or a constitutional provision specifically confers it on the central government. And that is why the correct answer for this question herein is option B, statement number 2 only. Now let us proceed to the next question of our today's discussion. So the question is, with reference to the interstate councils, consider the following statements. Your statement number 1 is, it was set up on the recommendation of the Sarkaria Commission. It is an independent statutory body. The function of the council is complementary to the Supreme Court's jurisdiction under Article 131 of the Indian Constitution. And your statement number 4 is, the Prime Minister acts as a chairman of the council. So how many of the statements given above are correct? Your option A is 1 only. Your option B is 2 only. Your option C is only 3. And your option D is none of the above. So the correct answer for this question is going to be option C. Only 3 statements herein are correct. So on the recommendations of the Sarkaria Commission, Interstate Council was established in the year 1990 through a presidential order, and that is why your statement number 1 is correct. Interstate Council is a constitutional body. It is not a statutory independent body, rather it is a constitutional body. And where it is mentioned under Article 263 of our Indian Constitution. So basically Article 263 of the Constitution provides for a mechanism known as Interstate Council to ensure coordination and cooperation among states and also between states and the central government. And that is why your statement number 2 here is incorrect in nature. The council functions to inquire and advise upon interstate disputes, and it is complementary to the Supreme Court's jurisdiction under Article 131 of the Indian Constitution, which provides original jurisdiction to the Supreme Court of India to settle dispute between center and the states or between 2 or more states. However, the council's function is advisory in nature. And that is why your statement number 3 here is correct in nature. If you talk about the composition of the interstate councils, it consists of the Prime Minister as the chairman, then Chief Minister of all states are members, Chief Ministers of the Union Territories having a legislative assembly, and administrators of Union Territories not having a legislative assembly as members. 6 ministers of cabinet rank in the Union Council of Ministers to be nominated by the Prime Minister of India. And that is why your statement number 4 here is also correct in nature. And hence we have the correct answer. Only 3 statements are correct because the Interstate Council is not a statutory body, rather it is a constitutional body. Now moving forward to the next question of our today's discussion. So the question is, consider the following statements with reference to zonal councils. So first statement is they are statutory bodies. Your second statement is they are established by an act of the parliament, that is State Recognition Act of 1956. Your statement number 3 is the Prime Minister is the common chairperson of the zonal councils. So how many of the statements given above are correct? Your option A is only 1. Your option B is only 2. Your option C is all the 3 statements are correct. And your option D is none of the statements given herein are correct. So the correct answer for this question is going to be option B. Only 2 statements are correct. The idea of the creation of zonal councils was mooted by our first Prime Minister, Pandit Jawaharlal Nehru, in the year 1956. The zonal councils are statutory bodies and they are established under the State Reorganization Act of 1956. Currently, if you talk about, there are 5 zonal councils: Northern, Central, Eastern, Western and Southern. And the northeastern states are not included in the zonal councils and their special problems are looked after by the Northeastern Council. Northeastern Council. Set up under the Northeastern Council Act of 1972. The Union Home Minister is the chairperson of the 5 zonal councils and chief ministers of states act as a vice chairman of the council by rotation, holding office for a period of 1 year at a time. Hence, your statement number 3 is incorrect in nature. So, they are statutory body and they are established by an act of the parliament, that is the State Reorganization Act of 1956. Both of these statements are correct and that is why the correct answer for this question is only 2 statements. Moving forward to the next question of our today's discussion. So, the question is, consider the following statements with reference to the Northeastern Council. So, your first statement is Northeastern Council is a statutory body. Your second statement is West Bengal, Assam, Manipur, Meghalaya are among the states that are represented in the council. So, which of these statements given above are correct? Your option A is 1 only. Your option B is 2 only. Your option C is both 1 and 2 and your option D is neither 1 nor 2. So, the correct answer for this question is going to be option A. Only 1 statement is correct. So, the Northeastern Council is the nodal agency for the economic and social development of the Northeastern region, which consists of the 8 states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim and Tripura. West Bengal comes under the Eastern Zonal Council and that is why your statement number 2 is incorrect in nature. It is established by an act of the parliament, the Northeastern Council Act of 1971. Northeastern Council Act of 1971 and that is why it is a statutory body. and that is why only one statement is correct, that it is a statutory body. Now moving forward to the next question of our today's discussion. So consider the following statements regarding the President rule, and you have to tell me which of the following statements are correct. Okay, so your statement number 1 is a law made by the Parliament or President lapse just after the revoking of the President rule. Your statement number 2 is the President can assume to himself the power vested in the concerned state high court during the President's rule. So select the correct answer using the code given below. Your option A is 1 only. Your option B is 2 only. Your option C is both 1 and 2, and your option D is none of the above. Okay, so the correct answer for this question is going to be option D, neither 1 nor 2. That means both of these statements are incorrect in nature. The President or Parliament or any other specified authority, if they legislate on any subject, it continues to remain operative even after the President rules. Okay, enforceability of law passed during the President rule is not coterminous with the duration of the proclamation. And that is why your statement number 1 is incorrect in nature. The President acquires the following extraordinary powers when the President rule is imposed in a state. Firstly, he can take up the functions of the state government and powers vested in the governor or any other executive authority in that state. He can declare that powers of the state legislature are to be exercised by the Indian Parliament. He can take all necessary steps, including the suspension of the constitutional provisions relating to any body or authority in the state. However, the President is not authorized to assume the powers of the High Court or to suspend any constitutional provision pertaining to it, and that is why your statement number 2 is also incorrect in nature, and that is why your statement option D, neither 1 nor 2, is the correct answer for this question. Now moving forward to the next question of our today's discussion. So the question is, with reference to the period of proclamation of national emergency, consider the following statements. Your statement number 1 is, it must be approved by both the houses within 6 months from the date of its issue. Your statement number 2 is, it can be operation for an indefinite period. Your statement number 3 is, it does not require periodical parliamentary approval. So how many of the statements given above are correct? Your option A is only 1. Your option B is only 2. Your option C is all the statements are correct, and your option D is none of the statement given herein are correct. So the correct answer for this question is going to be option A. Only 1 statement is correct. So let us talk about the parliamentary approval and duration of the national emergency. The proclamation of the emergency must be approved by both the houses of parliament within 1 month from the date of its issue. So the period is not 6 months, it is 1 month. And that is why your statement number 1 is incorrect in nature. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved, or the dissolution takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha in the meantime has approved the national emergency. So If approved by both the houses, the emergency continues for 6 months. For 6 months, and it can be extended to an indefinite period with an approval of the parliament for every 6 months. And that is why your statement number 2 here is correct in nature. Every resolution approving the proclamation of emergency or its continuance must be passed by either house of the parliament by a special majority. This provision for periodical parliamentary approval was added by the 44th Amendment Act of 1978. We know that the 44th Amendment Act of 1978 made various important constitutional changes. It also undid the various changes that were made by the 42nd Constitutional Amendment. And after the 44th Constitutional Amendment, you require the periodical parliamentary approval, and that is why your statement number 3 here is incorrect in nature. Now proceeding to the next question of our today's discussion. So the question is, which among the following statements are correct regarding the effect of the national emergency on fundamental rights guaranteed to us under Article 19 of the Indian Constitution? So statement number 1 is, the fundamental rights under Article 19 can be suspended during war, external aggression and armed rebellion. The suspension of fundamental rights under Article 19 during the emergency needs no presidential order. Only those laws which are specified in the presidential order are protected from judicial review. How many of the statements given above are correct in nature? Your option A is only 1, your option B is only 2, your option C is all 3, and your option D is none of the statements given herein are correct in nature. So the correct answer for this question is going to be only 2 statements are correct in nature. So basically Articles 358 and 359 describes the effect of a national emergency on the fundamental rights. And what are these 2 provisions? So suspension of fundamental rights under Article 19 of the Indian Constitution. According to Article 358 of the Indian Constitution, when a proclamation of emergency is made, national emergency, 6 fundamental rights under Article 19 are automatically suspended. Automatically suspended. Article 19 is automatically revived after the expiry of the emergency, and that is why your statement number 2 is correct in nature. The 44th Amendment of the Indian Constitution laid down Article 19 can only be suspended when the national emergency is laid on the grounds of war or external aggression. So only on the grounds of war or external aggression, and not on the ground of armed rebellion, and that is why your statement number 1 is incorrect in nature. Suspension of other fundamental rights. So under Article 359, the President is authorized by order the right to move any court for the enforcement of fundamental rights during a national emergency. Thus, Article 32 is suspended and not the fundamental rights. The suspension of enforcement relates only to those fundamental rights that are specified in that particular presidential order. The suspension could be for a period during the operation of emergency or for a shorter period. The order should be laid before each house of the parliament for approval. The 44th Amendment Act of the Indian Constitution also mandates that the President cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed to us by Article 20 and 21? And this is also a very famous question in various competitive examination, that even during the national emergency, which of the following fundamental rights cannot be suspended? So Article 20 and 21 cannot be suspended even during the proclamation of a national emergency. And through which amendment you have this mandate? You have this mandate by the 44th Constitutional Amendment. The 44th Amendment Act of 1978 provided that those laws which are not related to the proclamation of emergency can be challenged in the court even during the emergency. And that is why your statement number 3 is also correct in nature. And hence, the correct answer for this question is going to be option B. Only 2 statements are correct. Now let us discuss a practice question for our today's session. So the question is, consider the following statements about the high courts in India. So your statement number 1 is, it is the Parliament of India which specifies the strength of the High Court. And your statement number 2 is, the judges of the High Court is appointed by the governor. So which of these statements given above are correct? Option A, 1 only. Option B, 2 only. Option C, both 1 and 2, and option D is neither 1 nor 2. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.